Thank you, everybody, for being here today. I hope you find this very fascinating. I've been working in IP for a long time. I find it fascinating. Sometimes it can be boring. So I'll try to make it as interesting as I can for you. So as Ahmed said, my name is Sonia Patenaude. I'm an IP manager at Intellectual Property Ontario. I am a registered patent agent. I've been working in the IP field for over 20 years. I worked at the federal government, SME in Ontario, private law firm, and now at the government of Ontario. I've done everything from patent agent, IP strategy, all the way to IP related agreements such as licenses and commercial licenses, research collaborations, et cetera, et cetera. So I've been, dabbling in a little bit of everything. We have a lot to cover. IP fundamentals, IP 101. It takes I'm going to struggle to make it in the time. I invite you to ask any questions that you have as we go online. I'll try to keep an eye on any questions from your side. Ask them when they come up, because sometimes if you wait, you lose the context and therefore the value of your question. I will try to fit all of the questions in. If I don't answer your question, please come see me after and I'll do my best to answer it at that time. So as with any talk about IP fundamentals, let's start with what IP is and how you protect it. So IP is a creation of the mind. And by that, I don't mean just an idea. An idea is not considered to be intellectual property itself. It's the reduction of that idea to a concrete form that is the intellectual property. So it can be in the form of all sorts of things: inventions, logos, names. It can be in the form of a design. It can be a creative work, so literary or other work. And there are other types of information that can also be considered to be IP. So it can come in all sorts of forms. If any of you have read, an online article today, or you've listened to a podcast, or you went to your favorite coffee shop to get a coffee, I can guarantee you have interacted with IP. It's everywhere. And sometimes we don't even realize it. So let's go through some of the, let's go through what intellectual property is. And then also I'd like to differentiate what intellectual property is from intellectual property rights. So IP rights offer protection for your intellectual property. They are registered rights within various jurisdictions. So what do we do? What do we get from registering or obtaining IP rights? Why would we want to register them? They offer certain things like it's proof that you own the creation or the invention. It can be a bonus if you have to assert your ownership over your IP for someone. It can give you exclusivity to that particular invention or creation. So you can prevent others from using it or from claiming it as their own if you have registered it and you have proof that it is yours. This exclusivity only lasts for a certain amount of time, and that period of time will differ based on the type of IP right that we're talking about. Now, today we're only going to discuss some of the IP rights that are out there and some of the IP. The most commonly recognized ones are patents, trademarks, designs, copyright, and I'll also talk a little bit about trade secrets, because while they are not strictly an IP right, they can form a really important part of your IP strategy. So let's start with inventions. Oh, see, you already saw the next slide. I've let the cat out of the bag. So inventions are a concrete and innovative solution to a problem. That solution can be in the form of a product, a machine, a process, or a composition. The thing about inventions is they have to have a functional aspect to them. We're not talking about appearance, we're talking about function. So patents are the IP rights that will protect inventions. There's a lot to know about patents, and usually this is the form of IP that everybody equates to IP, right? If you think IP, you think of patents. This is not the only one. But patents, they protect your inventions, and they protect, as I said, the functionality of your invention. They don't protect any of the appearance of your invention. And in order to obtain a patent for your invention, you have to check certain boxes. There are certain requirements that you have to meet. The first is that you have to have patentable subject matter. So some things have been determined to be patentable. As I said, product, machine, process, composition. But within this sort of area, some things have been determined to be not patentable by statute. So the Patent Act lays out that you can't patent discoveries, laws of nature, purely mental operations, or mathematical formulas. In other cases, the courts have established that certain things are not patentable. So those things include methods of medical treatment or surgery. I'm drawing a blank all of a sudden. Things are usually methods that require professional skill, and higher life forms are not patentable either. So animals and plants, you cannot patent those. There's ways around it. As with a lot of things in IP, the answer is often that depends. So the other thing that you have to meet is the criteria for patentability. So as shown here, your invention has to be new, inventive, also referred to as non-obvious, and useful. So what do we mean by new? New means your invention cannot have been known anywhere in the world prior to you filing your patent application for that invention. That's a pretty high standard, and it's really difficult to evaluate that. So practically speaking, what happens is the examiner at the patent office will look at all published material to see if your exact invention was described. With respect to inventiveness, so it has to be inventive or also non-obvious. That means a person that has skill in that particular area of technology, just regular skill, can't have thought of that as sort of like a natural what's next in that area of technology. The other benchmark is maybe would they have thought of it if they had read an article and put their knowledge together with that printed document and arrived at your invention. Now, one way that you can really demonstrate that your invention is not obvious is when there is some surprising effect to it or some surprising result from it. It works better than you would have thought. It works faster than you would have thought. It is more effective. It is more something than you would have thought. So that is a really great way of knowing that you have something that is not obvious, is when you have an unexpected result. Usefulness for an invention is sort of in two different ways. First of all, your invention has to have a function. And second of all, it has to work. So you can't just have a function. If you describe a process in order to obtain a patent, you have to demonstrate that that process actually works and does what, you'll obtain at the end, what you say you will obtain. Yeah. Yeah, so the question is, how do you prove that something is inventive? It is a very subjective type of argument, and usually that is where a lot of the back and forth with the examiner to try to convince them that no, in fact, a person of regular skill in that art is what we call them. A person of regular skill would not have thought of this, and this is why. So it is kind of tricky. It's a difficult one sometimes, especially in a really crowded art where you're trying to, show that there's one particular thing. Sometimes it's a matter of obtaining an affidavit from someone who is, well-versed in that particular field and having them lay out why exactly it is new and inventive. So there are different ways of demonstrating that, but it can be rather difficult. And usually anytime you get an obviousness objection from an examiner, when it keeps going on and on, you start to kind of go, oh, it can be quite frustrating, but it is more difficult and more subjective than demonstrating that something is new, because if it's new, it's not new, it's completely described in a document. So there's a question here that says, all natural phenomena such as DNA methylation signatures patentable. So That is a very good question. Usually, as I said, discoveries are not patentable. You can't just go, oh, I discovered that this happens in the human body. What you can patent is an application of that. So if you've discovered a natural process in the body, if you then figure out how to manipulate that, that may be patentable. So that particular discovery is not, but an application involving that discovery may be patentable. Again, it depends. The next requirement is you have to provide an enabling disclosure of your invention. And what does that mean? That means in your patent application, which you're going to file with the patent office to ask for a patent, you have to provide sufficient description for a person of skill, regular skill, lab tech type person, to be able to take that description, read it, and make and use the invention. So you have to give a quite fulsome description of your invention in order to obtain a patent. The reason for that is because patents are a bargain with the government. In exchange for them giving you a period of exclusivity over your invention, you are giving the public a full description of your invention so that when your patent is expired, the public can then take that and fuel innovation by continuing development on that type of technology and can use it freely. So patents are jurisdictional, which means that they can only be enforced in the country or jurisdiction in which they are obtained. So if you want patent protection in the US, you have to seek it in the US. And if you want patent protection in Canada, you also have to seek it in Canada. And if you want patent protection in Australia, you also have to seek it there. So you can start seeing very quickly how it can become very expensive in order to obtain this worldwide patent protection. I can guarantee you there is not a company on earth who files in every country on earth because it is just too expensive. Yeah. We'll get to that in a little bit. So the question here was what about WIPO? So WIPO, they offer, so you can file an international application called a Patent Cooperation Treaty application. And we'll talk a little bit about that a little bit later when I talk about timelines, okay? So if I don't answer your question there, you make sure you bring it up again. So as I said, they're jurisdictional. You have to obtain them in the countries, every country where you want to have protection. Now, what does the patent give you? The patent gives you the exclusive right to that invention, which means you can exclude others from making, using, and selling your invention. Whatever you have obtained protection on, you can exclude them from making that, which means you can exclude them from entering the market there. Yeah. However, that's very exciting. However, you should note that that doesn't mean that you have the ability to practice your invention. So if you'll recall, it can be improvements. A lot of patents now are improvements. Most patents are improvements on existing technology. So if someone has patented the existing technology underlying your improvement, in order to make a product that includes your improvement, you may have to use that underlying technology, which means you will have to go request permission from that patent owner to use their IP. So sometimes, as soon as you're making an improvement, the first question you should ask yourself is, who owns this existing technology? Do they have an active patent in this country? So, yeah. So that is a very good question. So the question is, does the improvement prevent the person who has the original patent from practicing the improvement? So let me give you an example. I like examples. Examples really show what we're talking about. So if you have invented the doorknob, you have a patent on the doorknob. I come along and I'm tinkering away and I figure out a way to incorporate a lock into that doorknob. Now I have a doorknob with a lock. This is great. I obtain a patent on the doorknob with a lock. I can do that without any problem. However, as soon as I want to go and manufacture and sell that, I need your permission because I'm going to incorporate your technology into mine. So I'm gonna go see you and say, I would like a license to your doorknob technology. And you're gonna say, great, I would like a license to your improvement. And so there's a cross licensing opportunity there where he licensed me his technology and I license his, and then we can both, I can make doorknobs with locks or without locks, and so can he. Usually with licenses, what you do is you certainly limit the area in which you are giving your rights to. So you can, you can say, fine, you can make a doorknob with a lock, but you can't make any without locks. So that's how that will work. So yes, in fact, my IP rights would prevent you from incorporating the exact same thing into your technology, but there are ways around that. So do you invent a new lock then that works in a different way that still locks the doorknob, but then gets around what I've invented? So there are definitely different approaches. Quite often, though, a cross-licensing opportunity is really a good way to monetize your IP, to make money off of it. So, as I said, I like stories, I like examples. Who knows what this is? Come on, somebody. Thank you. I knew I had you guys in. All right, so this is the balloon expandable stent. So I'm going to tell you a very, very high level summary of the IP situation with the balloon expandable stent. Who knows the IP story here? Okay, good. Because there's nothing I like more than telling a story where people don't know the details. So in 1977, Andreas Prinzig performed the first successful coronary angioplasty. And in 1978, he gave a talk at a conference, I think it was in California, where Julio Palmaz attended, and he listened to that talk. And then Palmaz got the idea for a stent but that doesn't mean he has any IP left. So off Palmaz goes to his kitchen, where he designs the prototype and he puts it together with copper wire from Radio Shack and a soldering iron. Perfect. So he continues to, he's trying out his prototype, tries it out, tests it out on some small animals, sees how it works. In 1983, he moved to San Antonio because he needed to find partners to help develop this technology because he could no longer do it himself. So then he met Richard. Okay, somebody help me here. Richard Scatz. Which one is it? I'm French. I don't know which one it is. Okay, we're going to go with Schatz because that's easier for me to say because I'm French. So he meets Richard Schatz, a cardiologist, a military cardiologist who thinks that this is pretty cool. So they partner up and continue development of the stent. So now he's working with machine cutting on metal tubes and so on and so forth. But these guys need some money because development of this type of technology is pretty expensive. So is testing. So they need some money. This part of the story is a little weird. They meet, let's see, Phil Romano. Phil Romano is a restaurateur in Texas who owned two very well-known restaurant chains, Macaroni Grill and Fuddruckers, which he recently sold. So he had some money to spare. So he partnered with the two others. They formed the Expandable Graft Partnership, and off they went with trying to continue development of this stent. Later that year, in 1985, they filed the first patent to the stent. Oh, geez, that's slow. And I was kind of hoping you'd be able to see it, but I could just point here, but you won't be able to tell. So this was filed in November of 1985, and it was issued in March of 1988. As you can see up there at the top right corner there, that's the issue date. So they filed the first patent in 1985 to the stent in this embodiment here shown on the front. That led to other patents which were filed later on, and those are shown here. You can see that they're directed to similar but different embodiments of the same invention. And this last one right over here on the right, for those of you online, this is the Palmaz Schatz version of the stent, where smaller stents are connected to other stents by little bridges, which increases flexibility and navigability. So that one, interestingly enough, was filed a day before the issuance of this patent. And it's a long story. We won't get into the whys and wherefores of that, but you can see that multiple patents came from one invention. just because they work a little bit differently, and so they were filed on different environments. So in 1986, Expandable Graph Partnership decided it was time to start shopping this around. So they presented it to a number of larger companies, most of whom declined the technology. They didn't want to take it up, they didn't see the value, or they thought it would be too expensive. This included Boston Scientific, and keep that name in mind because it'll come up later on in this presentation. But Johnson & Johnson took up the technology, they took a license to it, and then they sunk $100 million in continuing its development and obtaining FDA approval, which was obtained for coronary applications in 1994. So, as you can imagine, with a stent technology like this is a foundational technology, it's brand new, first of its kind-ish, first of its kind. We're going to show this like this. And as I mentioned earlier, there can be a lot of improvements and variations on a technology. And in this case, there were. And I'm about to show you exactly how many there were. This diagram is a little bit old, but you can see that all of these little branches, these are all different patents that were filed based on the Patenaude patent, which was in the middle there. So each one of these people is going to need permission from the original patent holder in order to put that invention into practice. So you can start to see where one invention, you have improvements and improvements and improvements. This doesn't even take into account improvements in the last, 5-ish years. So it really allows you to grow. So any questions on patents? I find it hard to believe there are no questions on patents. Okay, let's start at the front and moving back. Yeah.
I don't know if this is what is defined as a meaningful difference when you're put that word into new patent.
So it's easier for me to tell you what is not a meaningful difference. Okay, so the question is, what is a meaningful difference when we're talking about obviousness with respect to patents? So it has to be something that is substantive. So you can't just change. Let's say your product is made of a certain material and you change that for better, higher quality material. That is not a substantive change. If you change one material for another that's equivalent, that's not a substantive change. So you can see that it has to be something that it's usually in the function, right? It almost always is based on function and how you describe that function. So let's say and there are patents of this nature. So in pharma, if you have a drug that is known, I don't know, a drug to treat acne, okay, just picking something here. So you have a drug that treats acne and you have a patent to that, great. But you find that that drug can be used to treat liver cancer. This is a completely new application of that drug. That is not obvious. It would not be obvious to take a drug that treats acne and use it to treat liver cancer. Okay, so different applications, as I said earlier, better results, surprising results, synergism, that sort of thing really helps make the case for non-obviousness. Other things that could be used are better results in a very specific range that could not be predicted. This type of thing is what you're looking for when you're looking to show non-obviousness. Now, the best thing to do is obviously when you're working with a patent agent to write your application in the first place, they will definitely be able to kind of identify any areas where there may be some problems and where you may want to focus some of your efforts in describing what exactly is happening, how it happens, or anything surrounding the invention at that point. Sometimes it's also a question of, and in your fields, sometimes it's also a question of having data to show that you have this surprising effect. Right. And for me, my wheelhouse is antibodies. I had a lot of them. Yes, there's this antibody. Yes, you can obtain a whole bunch of antibodies, but this one acts better than the others for this reason. So that is how you can show that sort of thing. Who's next over here? Oh, there we go.
How specific do the applications have to be when filed? Like, let's say for a drug that you discovered in your, like you said, you're filing it for, let's say, diabetes.
Mhm.
Is there a way to kind of loosely, protect applications within, like, within its sector without actually saying what it is?
Right.
In case you need to develop them later.
Right. So the question is how specific do you have to be in description of the application of a drug, for example, when you're writing and filing your application? It's a really good question, and it is probably the most excruciating thing to try to figure out, because you're trying to tread a very fine line between giving enough description and getting the most protection that you can. But if you go too far, you might not give enough description, which could invalidate your patent. And if you go too broadly, and let's say you obtain your patent, you get this nice, great, big, broad patent, and you know, it's great, but somebody comes along and shows that that doesn't work in this particular case. Now you might be in trouble if you're not able to carve that case out, right? So if you say it works in, you know, what can I am trying to think of an example, but let's say you say it works in all cancers, but then somebody shows that it doesn't work in liver cancer. Well, if you have no method by which to carve that out in your patent is now invalid and you have nothing. And so it's a really fine line that you tread in trying to balance the right amount of disclosure and the right amount of protection with not being so narrow that anybody can get around it. Again, patent agents in whatever field that you're in, you know, you want to find a patent agent that knows what, you know, that understands your technology, that knows what they're talking about, that has experience in dealing with these things, that can go, you know what, we can get this broad. So when I patent antibodies, I know that I can get a claim that claims the antibody via the complementarity determining regions of an antibody, because that is very specific, because that is what binds your antigen. But I don't have to do all the constant domain region, even some of the variable domain region is not that necessary, but the complementarity determining regions, that's it. But then it's fairly specific. But if that is what serves your purpose, that's not necessarily fatal. So it's a bit of a balancing act. Oh boy, everybody, okay, go.
Just a quick question. What happens to that we have to pay them to get licensing? Also, the question is, if that's just for the US patent, what happens for people, let's say in Europe and Asia, to develop some things like another variation of this? What happened to them? Do they have all have to pay the license?
So the question is, what happened to the original patent? Do all the licensees have to pay, or does the original patent holder have to pay the licensees and other jurisdictions? So I didn't look into the full story because, you know, there's only so much time to prepare for these things. But I can tell you that if Dr. Palmaz wanted protection in Canada, he better have filed that patent in Canada. And in Europe, he better have filed it in Europe. And in other countries, he better have filed it in other countries. So if there is no patent protection in that country, Dr. Palmaz cannot enforce his US patent in Europe. He cannot enforce his US patent in Australia. He can only enforce an Australian patent in Australia. So if he didn't obtain patent protection in that country, then no IP rights can be asserted in that country. Okay. With respect to a licensing situation, it all depends on what the license is. If the license is simply licensing the Palmaz patent to others so that they can create the improvements, then the money only flows from the licensees to the original patent holder. Typically because you'll have the usual setup is royalty on sales. So you have royalty on sales flowing back to the patent holder. I think that's it, right? Okay. Who else had a question? Okay, oh my, see, I knew there were lots of questions about patent. Okay, 2 more questions and then we'll move on so that we can cover the other stuff, but I invite you to come and see me after and I'll be happy to answer any of your questions. You've got lots of questions, so how about you? Yeah, go ahead. Yes.
Does the original, can they, when they're refiling the patent, can they like improve it or make any changes, or does it have to be exactly the original for it to extend its duration?
Right, so extending the duration of the patent is the question, and whether you have to file or refile. So unfortunately, once you have your patent and it has gone the 20-year duration, that's the end of that. Because if you tried to refile the exact same thing, they would point to the other one and go, you already had that. That's already known. So if you want to file something new, it has to fit all the criteria of patentability. So it has to be new and inventive and useful. It has to be patentable subject matter, and you have to have an enabling disclosure. All those things have to be true. So again, you'd be looking at an improvement or some variation that gives you a surprising effect or something like that. Okay, one more question. Okay, let's go with the green shirt.
Oh, no.
Okay, this one here.
Wonder, what about the research that happens before patent? And as you said, about conference talk and say the public.
Yep, so we'll talk about disclosure. So the question is, what about the research and prior to filing? And I'll tell you, we'll talk about disclosure in a little bit. And since you're in person, you'll have the opportunity to talk a lot about it in the workshop portion. Okay, so again, any other questions, please see me. I'm happy to answer. It's just I do want to get to some of the other stuff. So the next thing I want to talk about is branding. Branding is about the image and the reputation of a company or a product. And you want, the recognizability of a product. And that can be achieved by a number of different things. And usually the elements that distinguish your goods or services from somebody else's. And those elements can be logos, it can be slogans, it can be names, anything that provides you with some sort of recognizability. So the IP right that protects your brand is trademarks. So this is the IP right that is primarily involved in branding, is trademarks. So there are registered trademarks denoted by the R, and there are unregistered trademarks denoted by the TM. So unregistered trademarks are just that. You don't have to register them. You can have some common law protection. They only have regional protection, which means you'll have those common law rights in the region in which they are used, in the region in which you advertise or something like that. So it won't be very widespread, and you typically may choose to do this if you are a small company, or if you only have a very small area in which you do business, or maybe even that you aren't going to use the trademark for that long. Registered trademarks, on the other hand, they again offer you some advantages. So it's, it will show that the mark is yours if you register it. It will be presumed to be valid by the courts if you enter into litigation. And certainly registered trademarks definitely offer better enforcement options, particularly if you're trying to enforce them online. So there are different programs and different things that allow you to enforce your trademarks. Definitely, if you're doing anything online, registering your trademark is probably a good idea. So what kind of elements can be protected by trademarks? These include, there's a lot of different things. The most common one, words, designs, textures. You'll have a lot of colors that can be protected, sounds. So if anybody can think, who here can think in their head and hear the McDonald's little jingle, da, 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 that's trademarked, and for good reason, because it's super catchy and everybody recognizes it right away. You definitely think McDonald's as soon as you hear it. And there are a lot of different ones. that are like that. Anybody know that, that Hunger Games whistle that they have, that is trademarked by Lionsgate Films because everybody knows that. So if they use that, generally people think Lionsgate or Hunger Games. And so there's a lot of different things. Now, there is others like holograms and moving images and three-dimensional shapes and modes of packaging. In Canada, we're a little lagging behind in some of the registrations in some of these categories. But in the US, there's a lot of colors and scents, tastes, believe it or not. So definitely a lot of different elements can be trademarked. And you can also combine some of these elements. So a logo with a name, or a logo with a catchphrase or what have you. So all of these things can be registered. Things to know about registered trademarks is it can't be descriptive. So you can't trademark the word apple when you're talking about apples, right? You can't, as an Apple distributor, you can't trademark the word apple. But because that is descriptive of what the good is. But you can trademark it with respect to computers because not a lot of computers look like an apple. So Apple was trademarked with respect to in the computers field. So that is also something that happens when you register your trademark. You do have to choose what class of goods or services that you are registering it in. So that allows me to trademark Apple in use in the electronics area, whereas you might be able to trademark Apple in the use of cars. It's completely different, and nobody would mistake Apple, the car company, with Apple, the computer company, particularly since their logos are likely to be much, much different. Again, this allows you the exclusive right to prevent others it allows you the exclusive right. You can prevent others from using your trademark, from trying to pass off their goods as yours, etc., etc. Trademark registration lasts for 10 years, but it can be renewed. So it's as opposed to patents, which cannot be renewed. Trademarks can be renewed every 10 years indefinitely. So Coca-Cola has had their trademarked for their name trademarked for 100 years. And that's how they do it, is it can be renewed over and over. So when you think about our scent example, you might think, trademarks, well, there are quite a few. I've put some up here on the screen. Okay, there we go. So you can see that some companies have chosen to use their unregistered trademark with respect to the name of their scent or that particular piece of technology. And you'll see Synergy, Nucleus, Superflex, they're all unregistered trademarks. Whereas the others, which I haven't put the R because I just pulled them down from the USPTO website, you can see that those are registered trademarks, but they have chosen to register them. And some of them endure ever since the beginning, Palmaz Schatz. So those are registered by Johnson & Johnson and they still hold those today. So any questions about trademarks? Yeah. They are different. So the question is trademarks and copyrights are different. They are different. There can be some overlap. Okay. So if you draw a logo, then that could be copyright, but then you register it as a trademark as your logo. So it can be, you can have overlapping protection of many of these things. Yeah. And patents? Yes. So the question is there a big difference in fees with respect to patents and trademarks? So yes, there is. Trademark protection is far less expensive than patent protection. And that's because there are less fees involved in trademark protection and also the work involved. So there will be a lot of, it's pretty intense, the amount of work when you're preparing a patent application. Patent applications tend to be 30, 40, 50, 60, sometimes 100 pages long to fully describe your invention and to provide sufficient evidence that it works. Whereas a trademark application is quite simple. It's basically a form and you provide, the visual items that you need if you have a logo or what have you, but it is essentially a form that you then file at the patent office and then maybe there's some back and forth, but not as much as in the past. And then obviously the more jurisdictions still that you file it in, the more expensive it is, but the fees are a fraction that of patent protection. Anything else on trademarks? Oh, yeah. Clinical trials they involve IP, but are not strictly IP. So I can't speak to clinical trials. It's a regulatory issue. But we get that question a lot. But no, we don't have a lot to do. Usually there will be some IP related clauses in your agreements for clinical trials, etc. But clinical trials themselves are not part of the IP process. Okay. So we'll move on to product design. So product design, a lot of products can have new appealing appearances that can allow you to immediately identify a product, and that can be very, very valuable. So, the obvious example, the Coke bottle shape. The design of the Coke bottle, it's very, very recognizable, and is valuable as IP. So how do you protect that product design? Well, those are protected by, in Canada, what's called industrial designs. In the US, they're called design patents, effectively the same thing. And design patents, or I'm just going to call them designs, it makes it a lot easier. Designs protect only the appearance of your IP. So of your product design, only the appearance. There can be some function to it, but what we're protecting with the design is only the appearance. If you wanted to protect function, that would be protected by patents. So here we're protecting the appearance. The appearance can be shape, configuration, pattern, ornament, or a combination. So think if I design this fancy new chair that has a really ornate back, that's really cool, I can protect that design. That doesn't mean that I have to show that the whole concept of a chair is new. It's just I can protect that particular design. Yeah.
How often are design patents, specifically for medical devices, filed along with patents?
So the question is, how often are design patents filed along with patents, particularly with respect to medical devices? And they can be quite a bit. When I worked at the law firm, I did some industrial designs, and every single industrial design I did was for Becton Dickinson. And almost all of them were for syringes. So, and I pulled a bunch of examples for a different talk I did, but Becton Dickinson has all sorts of product designs, syringes, catheters, the bits that connect the two together. I don't remember what those are called. They have PCR plates, they have everything under the sun. So you can protect a lot of different things with respect to your medical device. The question is, probably what you would want to ask yourself is, what is the likelihood that somebody's going to try to make it because that product is recognizable that way? Or is there value in the shape of this medical device in this particular way? Can I potentially use that to my advantage? So you have to evaluate whether there is value there, but there's all sorts of things that have design patents or industrial designs. The layout of the BlackBerry, I'm probably talking to the wrong audience here. You're a lot younger than I am, but the layout of the BlackBerry keyboard, that was protected by industrial design. The layout of a lot of the newer things with respect to apps can be protected by design patents, the layout of the app interface or the layout of the iOS screen, protected by industrial design. So all sorts of things across the board at any different stage can potentially be protected by design. But again, you have to evaluate what sort of value is there. So in Canada and the US, industrial design or design protection lasts for 15 years. There is international protection available as well. Sometimes the term of industrial design protection varies throughout the world. So back to our stents. Oh, wait, hold on. So there's a question here. Sorry, I cannot read with these glasses on. Could there be a deal made by the parent invention for extra income depending on how successful the child patent is, etc.? Yes, we'll talk about the value and the whole, the why patent protection can be important in a little bit. And I'll just finish this one. So back to our stent example. You'd think, okay, well, a stent is a stent. But just to give you an example here, these are 4 different design patents that were filed and obtained in the US. And you can see that the appearance of the stent is different in every single embodiment. And that is how you can obtain a design patent, because your appearance is different. Now, obviously there's function in the stent, but that is not what we're looking at here. We are simply looking at what does it look like. Okay. Any questions with respect to design? Yeah. There is overlap, and that's why I said earlier, you can have overlap between your protection. So you could have your stent, it works in a certain way, you protect the function of it with a patent. You protect the look of it with your industrial design. It's still the same thing, but so let me give you an example of a description of a design patent. The description goes something like this. The design of the stent as shown in figure 1. That's it. So you don't get a lot of description. It's like, look at the picture. If it looks like this, you're infringing. It's not very complicated, but as I said, there's a lot of value in designs. Anything else? All right. Next, we have creative works. This one is a hotbed of activity, because creative works are, it's basically all sorts of things that you see every day that you might not think of it. So you have creative work. What is a creative work? It can be a literary work. So a report, a thesis, a journal article. That's a literary work. A dramatic work is a performance of a play or in a movie or something like that. Artistic work, photographs, think photographs and pictures, and photographs and pictures, statues, paintings, things like that. Musical works speaks for itself. Computer software is a creative work, as is a recording or a broadcast. Okay, so those are the kinds of creative works. You see them all over the place. Articles, as I said earlier, podcasts, I've seen a picture today. Well, that's protected. So, and that can be protected by copyright. So copyright protects creative works that are original, expressed, and fixed. So original, what does that mean? That means that this creative work is new and is mine. So I have created a new work. It can't be copied from somebody else. So if I, copy a paragraph and put it in, that's not my new creative work. That is copied. Expressed means that it is the expression of the idea and not the idea itself that is protected. So let me give you an example, because this one is a little harder to grasp without an example. So if I write a novel about a boy who was abandoned as a baby and then raised in the jungle by wolves, I can copyright the novel. The novel is what is copyrighted, not the idea. So somebody else can write a different novel about a boy who was abandoned when he was a baby and raised in the jungle by wolves. But if that is a different novel, then that's okay, because the idea, the concept is not what is copyrighted. It's the actual work. And again, so yeah. So creative works, I mean, software is an interesting one, because it's a creative work And in my opinion, it falls under the literary because it's written, because it's code. Your code is copyrighted. Okay, so that's, to me, that's where it really falls. But we often state computer software because people don't think of it when they think of a written work. But because your code is written, it is it is protected by copyright. So the last one is fixed. And this means you have to have it in material form. I can't just think of my novel and that's copyrighted. I actually have to write it. That's usually that. All right, so copyright exists as soon as the work is created. Yeah,
Sorry, when you say fixed, does that mean it can't change ever again? Or if you have a copyright on something and yet you, let's say you approve your novel, can you then copyright that new novel?
yes, you could. I mean, but as I said, as I'm about to say, copyright exists as soon as it's created, right? As soon as your work is created. So if you rewrite a passage in your novel, then yes, that's copyrighted because, you know, you rewrote that passage in the novel. Now, generally, as you know, I mean, people don't, most people don't, you know, publish a new novel because they've changed a few pages. Some people do, but most people don't. So you could, in fact, change your work. Now, if you had, this is better expressed in the terms of, for example, your computer software example, you know, you have one version of your software and that's copyrighted. And then there are different, you know, you make changes to it and you improve it and whatever. And then you have a second version of your software, 2.0. Well, that's copyrighted as well. Usually, if we're talking about software, you usually see explicit new copyright when there's like, okay, we've achieved a critical mass of improvements and now we're releasing that as a new sort of package. Same thing with, you know, novels, or you'll have paintings or photos or something. Maybe somebody takes their earlier photo and makes some changes to it. It exists as soon as it's created. So it's one of those things that, do you really need to explicitly copyright it? No. And interestingly enough, you don't actually have to include the copyright notice in order to have your work copyrighted. But there are definite benefits to doing so, because the copyright notice is a notice to others that this is copyright. So obviously, if you write something, you know, with a copyright notice, that you'll see it. Every time that you publish your article, all the journals have the copyright notice. That's to put people on notice that there's copyright. Okay, was there one back here? Did I see? No, okay.
In terms, sorry, it's related to the software thing, but with software, are there only copyrighted, or are there opportunities for software as well?
Yep, so the question is about software and whether there are multiple ways to protect that, for example, copyright and patent, and yes, there are. For a long time, there has been a perception that copyright is, that software is too hard to patent. Years and years and years ago, when I was just starting out, and I'll tell you, I was a lot younger then, there was a bit of a time period where the USPTO and Canada, they were adjusting to patenting software. And so there were some growing pains, but now it has come to the point where, yes, you can obtain patents to software. My boss is a software guy. He has said that there is not a single patent application that he's filed that he hasn't obtained patent protection for on software. Typically, what you tend to do is the functional aspects of your software, like how it works, those can be patented. The interaction of your software with the hardware, that can be patented. So things that are functional, you would tend to protect with patents, because you're not going to be disclosing the code in your patent application. You're just going to be saying how the software works and what interacts with what and what it does, etc. Your code, that will be protected by copyright. Okay. So you see that there is overlap in that area as well. Anything else? Okay, two more. Yeah.
So this might be remember the AI.
Oh,
What is that? In terms of copyright, is the code base that created the decision?
Yeah, so generally, I'm gonna stop you right there, and the question is AI and copyright, and I can tell you that the IP and legal situation surrounding copyright and AI is kind of like unsettled across the board. There are a lot of questions, and there's not a lot of answers. I mean, as we were talking about this earlier, AI is moving really fast, the technology is moving really fast. IP is an old, paper heavy, really burdensome thing to move. It's really hard for it to keep up. So the Copyright Act doesn't really, you can't look to the Copyright Act to figure out who owns AI generated creative works. It's not helpful. So there's still a lot of unsettled issues with respect to that. You know, and I could list off all of the questions. Who owns the copyright in something created by AI? Is it the person who gave the prompt? Is it the person who wrote the software? Is it the person? I can't answer those questions because I don't think anybody can answer those questions for certain. Okay, last question. All right, perfect. 2 birds, 1 stone. All right, okay. So I'm going to fly through a little bit faster on some of these things because there's still a lot of things that I wanted to cover. And I have, you know, I'm at time already. And I know that Ahmed likes to be on time. So copyright protection lasts for the life of the author plus 70 years. That's true in most jurisdictions across the world. And generally, if you have copyright in Canada, through the action of the Berne Convention, it should be recognized in most of the other parts of the world. Okay. All right. So to give you an idea of how copyright could be applicable in our scent example, I've shown you here, and this is the Cordis website. Cordis was owned by J&J. All of this text is all put on their website and owned by Cordis, and they give you the notice right here at the bottom of their website. So if you have a company, you're, you know, putting together a website, copyright notice right at the bottom, every single page. Okay. All right. Quick word about trade secrets. Trade secrets in themselves are not technically an IP right. They can, a trade secret can be any information that derives its commercial value from its secrecy. So this can be a recipe, it can be a formula, it can be a compilation of information such as a supplier list or a customer list. It can be a method of making something or doing something. It can be an invention that hasn't yet been protected. It can be all sorts of things, any kind of information that has commercial value and the value is derived from its secrecy. There is no formal registration for trade secrets in Canada. Some jurisdictions like the US have enacted legislation that allows you to protect your trade secrets, but that is why it is so important to protect it, because there is no registration for trade secrets. Yeah. So with all trade secrets, it's a secret. It is essentially unprotected information. If it's out, there's no putting that toothpaste back in the tube. Once it's out, it's out. And then if you decide, oh, it's out, I'm going to try to patent it, it's been disclosed. It's no longer new. So be very careful with your trade secrets. So there's a lot of very important things that you have to do to maintain protection for your trade secrets. Yeah, go ahead. You don't so the question is, why would you want to register a trade secret? And the answer is you don't register it. There is legislation put in place that allows you to have protection for your trade secret, but it doesn't involve registration. What you do have to do is you have to demonstrate reasonable efforts, and I thank you for that, because that's a good segue to what I was going to say. You do have to demonstrate reasonable efforts to protect the trade secrets. So number one thing you have to show is that you have put in place and follow policies with respect to your IP and your trade secrets. You should demonstrate that you maintain an inventory of your trade secrets. So basically, you know what they are and you know who has access to them, and you limit that access. And when you limit disclosure of the trade secret, and if you do have to disclose, you use all possible reasonable means to protect that. So you use a non-disclosure or confidentiality agreement. Take your pick, pick your choice, it's the same thing. You train your employees to know what their obligations are with respect to trade secrets. You mark documents to show that they are proprietary information, that they should not be disclosed. So all of the, and more, these are all things that you should show reasonable efforts in order to maintain some semblance of protection in the US with respect to your trade secret. But all of that being said, if you have to sue somebody for theft of your trade secret, it kind of doesn't matter because your trade secret will still already be out there. Now you're just looking for damages with respect to it. Again, you're not putting the toothpaste back in the tube. You're just being compensated for having it explode out of there in the first place. So trade secrets, they're really tricky. So you do have to be very careful, limit disclosure, limit disclosure, limit disclosure. I can't say it enough. Yes.
Like, so how like the legal implications of actually, like, if somebody doesn't follow it, like, what are, like, is there any?
You can definitely sue them for breach of contract. That won't undisclose your trade secret. So the question was, what recourse do you have if somebody doesn't follow the NDA? You can sue them for breach of contract, but it won't undisclose your trade secret. It's still disclosed. So lots of different issues here. Who owns IP? Generally speaking, the creator or author or inventor is the first owner of the IP. In a lot of cases, the employer, if that creator, author, or inventor has made the invention or created the work in the course of their duties and used the resources of the employer, quite often the employer will own that that intellectual property and intellectual property rights. That is most likely to be laid out in your employment agreement where a clause with respect to IP ownership would be included. IP ownership can also be established by contract or agreement. So if you have a written agreement where it says Joe Blow is going to own the IP rights to this and the IP that's created in the course of this work, then that is how that's going to go. Intellectual property rights can be transferred from one person to another, and that's done through an agreement. That agreement is called an assignment, or it can be done through merger of companies, etc. So really the take home here is ensure that any of your agreements, when you're undertaking collaborations or partnerships or whatever, they lay out who will own the IP and the IP rights that are created in the course of the work that's being undertaken under that agreement. The other thing is if you own a company, make sure that your employment agreements include an IP ownership clause. Okay. Universities and IP ownership. This is really interesting. So university policy usually dictates who will own the IP rights to any inventions or any intellectual property that's developed. Okay. And these vary widely across the board. And I'm going to give you some examples here. So University of Toronto, if you make an invention that utilizes university resources, those IP rights are co-owned between you and the university. At Queen's University, if you use the university resources and create something in the course of your employment, you own it. At the University of Ottawa, the university retains ownership of inventions and research data unless that's done, there's a collaboration agreement or a sponsored research agreement to the contrary. And then finally at Carleton University, which is one of my favorites, because Carleton University is like, oh, we're not really sure what we want to do. And I'm okay with, picking on them. I come from Ottawa. So Carleton University, inventors and authors retain ownership of their IP rights, except if they use university resources, in which case we'll put together some sort of agreement. Not saying what that agreement's going to be. Okay. I will say this. I know most of you are researchers and students. Please have a look at the IP policy that governs your work. If you are cross-appointed to a university, have a look at their IP policy. See who owns any IP rights to the IP that you will create. It's important because that can eventually determine how everything goes down. What are the next steps when something's been created, etc. Okay. Yeah.
Like, in terms of, like, if we are signing up to, get an offer from a company or something like that, if there's a clause that says the company just owns all of our inventions, should we push for some kind of compensation for patents or like some kind of incentive for doing them? Or like, if you were in our
Yeah,
shoes-
no, I get you. So the question is there any practical advice with respect to, clauses in employment agreements or, ownership of IP, et cetera? Generally speaking, if you're being hired by a company to invent, they will want to own the IP rights to those inventions because they are paying you. It is your job to invent. They are sinking the money into the equipment that you are using, into the materials that you are using. It is their investment and you are creating it. Now, a lot of companies do have incentive programs for inventors. So and those can vary widely. It can be a lump sum amount. I'm from the federal government and at National Research Council in particular, and they had they shared the royalties with the inventors on a percentage basis. So there's a lot of different ways in which you can be compensated as an inventor. And if you are concerned with that, that would be a question to ask definitely right at the outset. What are your incentive programs? Okay, awesome.
Public and universities, to some degree, always negotiate.
Yeah, so and that's true. Yeah. So the comment was that may be true in private industry, but at universities it's usually negotiable. So look into it for sure. So how to protect IP and why? And I'm going to start with the why. So obviously protecting IP gives you exclusivity over that particular invention and I'm going to talk about inventions a lot because now we're really getting into the heavy duty patent intensive part. It gives you exclusive access to that IP. You can exclude others from using it. You can prevent others from entering the market. You can you can attract funding. So for startups, 58% of VC money goes to startups with patents. At the later stage, 81% of VC money goes to companies with patents. So attracting funding, definitely investors, they want to see that you have IP and that you're protecting it, that you have a strategy, that you can explain what that strategy is. Revenue generation. Well, let me just tell you this about revenue generation. It will definitely help you defray the cost of your patent protection. But let's return to our stent example, and then I will wrap it up because I think that Ahmed's gonna, kick me out. I'm gonna get the walk-off music that you get at the Oscars. So revenue generation. So as you'll recall, I said earlier that we have the Patenaude stent. Johnson & Johnson licensed the stent technology from the Expandable Graft Partnership. That deal was worth $10 million plus royalties. That's the license. And then in 1998, Johnson & Johnson bought the patents outright from the Expandable Graft Partnership. That deal was worth $500 million. Yeah. So, and then as I said, there's all these variations and improvements that are made, and all these people, they have to license the Patenaude patent from Johnson & Johnson. They're all paying royalties, or they're infringing. And of course, as with any infringement on a technology that is very, very valuable, there was a lot of litigation with respect to this, and it went on for years and years. Now, there was one particular litigation case that was a particular note. You remember I said Boston Scientific earlier? Boston Scientific. So Johnson & Johnson sues Boston Scientific. Boston Scientific has some patents. They assert those against Johnson & Johnson. The courts find that everybody's infringed on everybody else's IP. Okay. But Boston Scientific decided, okay, we are going to mitigate our risk and we are going to settle this. So that was the court finding. The next step was to find what the damages were going to be. But before they could get to that, Boston Scientific decided they were going to settle, and this is how much they settled for. $1.7 billion was paid to Johnson & Johnson for the infringement of the Palmas patents. That was in 2010. In 2011, Johnson & Johnson divested their entire stent business, sold that off. I don't know what the amount is, but they certainly got a return on investment for that. And the reasoning, in part, was, as a top executive at Johnson & Johnson said, they failed to develop the new generation of stents, and everybody who had those improvements and next gen technologies, they were ahead of them. And it was going to be too expensive to, you know, get ahead again. So they divested the whole thing. So revenue generation, there's the example. Now, not everybody's going to get a $1.7 billion settlement on their IP, but it just goes to show that, you know, this is how you monetize your IP. This is why you protect your IP, and this is how you monetize it. So disclosure, I know, Ahmed, I said I was going to wrap it up, but I do want to talk about disclosure, and you know I want to talk about disclosure. Disclosure of your IP before you secure protection can have devastating consequences. You all heard me earlier, and I know some of you kind of asked questions that have to do with this. The effect of disclosure is on patentability of your invention. If you disclose it before you file your patent application, it is no longer new. And depending on what you disclose, maybe you don't disclose the whole thing. Maybe you're like, oh, I'm just going to say this one little thing. Well, that one little thing can affect the obviousness of your invention. So it's very, very important to really examine your disclosures before you file your patent application. So what is a disclosure? Can be a publication. So let's talk again. We're talking books, we're talking articles, we're talking abstracts, we're talking theses, anything written. It could be other written material like slides, could be a poster at a conference, it could be a website, grant proposal that gets published online after it's been awarded. Think about those things too. So all of those written materials, they can be found and used as an indication that your invention is not new. Verbal disclosures count, folks. So lectures, symposiums, conversations with others, even if it's just one person. There is no limit. There's no, you know, you have to achieve this amount of people that you reach before it's considered a disclosure. There's not. It can be one person, and that's a disclosure. Basically, anything that is not protected by an obligation of confidentiality. If they have not signed an NDA, it will be considered a disclosure. Again, not related to the size of the audience at all. And again, it has nothing to do with the territory. So if you disclose in the US, that can be used against you in Australia. If you publish it in Australia, it can be, you know, when a Canadian examiner finds it, it will be used against you. So there's no jurisdictional limitations here. And I will say, and somebody's bound to ask it, I will say that no, an examiner will not, a patent examiner searching through documents will not find a verbal disclosure. But if you end up in court in a Johnson & Johnson situation and somebody can show that you have disclosed that invention before you filed your patent application, you're in trouble. They will find it and they will use it against you. I was at a talk a long time ago, and it really, really resonated with me. The person was talking about it was actually the person who invented the 3D puzzle, and they were going to court, and there were all sorts of, you know, it's kind of dirty pool when you're in litigation. So he said his, you know, his business partner was on a flight, and some guy approached him and started talking and said, oh yeah, no, I heard about your technology from this guy on this day. And you're like, I don't know what you're talking about. That was somebody that was hired by the opposition to try to get somebody to admit that there had been a disclosure prior to filing. So it's a dirty pool. There's lots of money involved. There are definitely going to be some questions involved. So definitely avoid public disclosure prior to filing your agreement, your patent application. Use confidentiality or non-disclosure agreements if you want to talk to people. Treat your data, your concepts, your ideas, your prototypes as proprietary information and trade secret. Keep them under wraps until you have protection. Ensure your employees understand what is a trade secret and what isn't, and what their obligations are with respect to those. So I'm going to skip over the patent protection timeline. Lots of things here. And I'm going to go straight to who can help you with IP. All of you have access to applied research offices or tech transfer offices if you're at colleges or universities. Business accelerators and incubators, as well as regional innovation centers, all have different people that can help you. Some of these different organizations are noted here. They don't all fit. There's a lot in the GTA. The Canadian Intellectual Property Office, if you're looking to find out more about IP or a specific type of IP, they have a lot of different free resources that you can go through, a lot of basic intellectual property knowledge. Explore IP is a marketplace, basically a database that's searchable. It lists all public sector intellectual property, so you can go and search it and you can have a look at it and maybe find some licensing or collaborative opportunities. IP Village is a collaboration between multiple different departments of the federal government to help small and medium enterprise in Ontario and in Canada, commercialize their IP. Global innovation clusters, those are federally funded clusters in different, digital tech, ocean technologies, etc., health tech. So you have a lot of different clusters that are put together and funded by the federal government. And finally, Pipeline, we're here to help you with your IP. We help small and medium enterprise as well as public sector, small and medium enterprise in Ontario with IP related supports, education, funding for obtaining IP protection and licensing and things like that. So we have a lot of opportunity for growth in Ontario, a lot of opportunity to learn. Please take advantage of these resources. Your universities and institutions, they almost all of them have tech transfer offices. University of Toronto has a very elaborate website that has a lot of information on it. Sunnybrook, sorry to say, but you have a little less information, but the person's name, which you can't read right there, Raphael something or other, you can contact him with respect to anything that is invention or IP. So please do that. Sorry, Ahmed. Thank you all for your patience, for your attention. If you have any questions, come to me.